Defense Fund's annual Supreme Court webinar, Civil Rights on the Line: What the U.S. Supreme Court Rulings Mean for You. If you experience any technical issues, please email events@naacpldf.org. This discussion is intended to provide general information. LDF is not providing legal advice. Thank you for joining us. We will now begin our webinar.
Thank you for joining us. I'm Janae Nelson, President and Director Counsel of LDF, the Legal Defense Fund. I'm delighted to welcome you to LDF's annual Supreme Court webinar, Civil Rights on the Line: What the U.S. Supreme Court Rulings Mean for You. The focus of today's discussion will be the impact of some of the key cases that were before the Supreme Court this term, ones that implicate civil rights, and in particular, some of the cases in which LDF was directly involved. The court's decisions and orders in these cases, good or bad, do not mean that our work in these areas is over. On the contrary, in many instances, a new chapter of our work has just begun. Our collective responses to these decisions will impact the very trajectory of our future as a democracy. It will determine whether we will be a nation that lives up to its full potential and that leverages its diversity to maximize our strength and competitiveness and to provide for the education and well-being of its people. Which pathway we take depends in part not just on the decisions of the Supreme Court, but on everyone on this call. So we are only a little over 6 months into his second term as president, and Donald Trump and his administration have aggressively sowed division, sanctioned discrimination, and excluded from power those who have historically been the most disadvantaged and vulnerable: Black people and all the intersectional communities they inhabit, and so many other marginalized communities. In many ways, this lawlessness has been enabled and, in fact, indirectly encouraged by actions and decisions of the Supreme Court. This past term, where the justices decided 56 cases consistent with the court's modern miniature docket, we saw continued departures from long-standing precedent, a rebuke of civil rights protections, a rare order to re-argue a gerrymandering claim in the case that LDF argued, and a series of scathing and scrupulous dissents from Justices Kagan, Sotomayor, and Jackson. We also saw continued growth of the so-called emergency docket or shadow docket, in which decisions are made with little to no transparency, but often with maximal detrimental impact. And perhaps most jarring was the court's own disregard for compliance with federal court orders. So the challenges ahead are formidable, but they are not insurmountable. LDF was built for moments like this, times when, amid precarity and chaos, clarion vision, sustained course, and fearless resolve guide us forward. And that's what LDF brings to the table, brings to the courtroom, and has been doing it for 85 years in our courts and in every other space of power to achieve justice, to advance the project of multiracial democracy that delivers to the people. So I am honored to lead an organization that has the drive and expertise and unwavering will to effect change, even as conditions seem dire. While attacks are coming from all directions, I'm confident that we will continue to meet these challenges with our partners and supporters like you. And now it is my pleasure to introduce Demetria McCain, LDF's Director of Policy, who will moderate today's discussion on the Supreme Court. Thank you again.
Thank you, Janae. And thank you, everyone, for tuning in today. I'm Demetria McCain, Director of Policy. I lead LDF's policy team and its very diverse policy advocacy portfolio, including working with senior leadership to actually set the strategic direction of LDF's legislative, policy, and advocacy work across the organization's 4 pillars: criminal justice, economic justice, education equity, and political participation. And I am pleased to facilitate this conversation about LDF's civil rights cases, which were actually decided during the 2024-2025 Supreme Court term. Today's discussion will include key issues facing the Supreme Court and, as Janae so elegantly stated, that collectively impact key aspects of our lives, particularly Black communities. And I'm delighted to be here with LDF's Associate Directors Counsel, Todd Cox and Sam Spital. Also with us today is our Director of Strategic Initiatives, Jen Hee Lee. And it's especially meaningful that today's conversation brings the four of us together, combining policy, legal strategy, strategic advocacy, and all of that wrapped up with our expertise. And it's especially a time when threats to democracy and the rule of law are actually mounting. It is more critical than ever that we bring the full force of our advocacy and our strategic litigation to advance and protect civil rights. So I'd like to start by asking them to briefly introduce themselves. And so I'm going to start with Todd Cox. I'll pass it over to you, Todd.
Well, thank you, Demetria. And hello, everyone. I've been lucky enough over the past 3 decades or so to do work in the racial justice, social justice arenas, and philanthropy and government, and in social justice organizations just like LDF. And I cannot be happier and more thrilled to be back at LDF in this new role, particularly given the moment that we're in. And I'm super happy to be working with my very talented, wonderful colleagues here at the Legal Defense Fund. Thank you.
Thank you, Todd. And now I'll pass it over to you, Sam.
Thank you, Todd, and thank you, Demetria. My name is Sam Spital. As Todd said, along with Todd, I am the other Associate Director Counsel at LDF. I have been at LDF for approximately 8 years. Until January of this year, I was the Director of Litigation, and I am very excited to be working with such an amazing group of people, both on the screen and at the Legal Defense Fund more generally, as we navigate these very challenging times, which Janae shared in her introduction, and we're going to get more into the details of the cases that have shown how the Supreme Court has contributed to the challenges that we face today.
Thank you, thank you, thank you. And last but certainly not least, over to you, Jen.
Thank you, Demetria. My name is Jen Hee Lee. I am the inaugural Director of Strategic Initiatives. I actually have been at LDF. This is my 17th year, so I have been here quite a long time, mostly in the litigation department until 3 years ago when Janae Nelson created the Strategic Initiatives Department. And it has been my honor to try to get this department up and running. It's a really exciting department. We house very discrete initiatives that intentionally integrate all the advocacy tools that we have at our disposal at LDF. So we marry litigation with policy and community organizing, strategic communications, and of course the wonderful research that we have available at our Thurgood Marshall Institute. And of course, now more than ever, we need all of the tools that we have available to us in order to really fight back against these authoritarian attacks on our multiracial democracy. And I am delighted to be here with my colleagues to talk about some of the most important Supreme Court cases that have come down this past term.
Thank you, Jen. All right, let's get started, why don't we? Now, many of you submitted very thoughtful questions in advance of today's conversation, and what we've done is we've woven them into the discussion. So we'll start where the Supreme Court ended the term, on birthright citizenship within the larger context of immigration, Trump v. CASA. Trump v. CASA is a case stemming from the Trump administration's executive order stating that children born in the United States to undocumented immigrants or to short-term visa holders would no longer automatically gain citizenship under the 14th Amendment's birthright clause. Sam, tell us more about this case, please.
Yeah, thank you, Demetria. So I think it's really important that we start there and start with what you laid out and maybe even take a step back and look a little bit about the history of birthright citizenship. Birthright citizenship was well understood to be a core part of American identity, of the Anglo-American legal tradition more generally. And it was so unquestioned for so many centuries And then something happened. In the Supreme Court's most notorious decision, the Dred Scott decision, the Supreme Court held that enslaved Black Americans were not citizens. And it did not matter if they were born in the United States or not, they were not citizens of the United States. And that decision was part of the catalyst of the events that led to the Civil War and Reconstruction. And in Reconstruction, the Congress passed and the states ratified the 14th Amendment. And we talk a lot about the 14th Amendment because of its equal protection clause, the principles of due process, these sort of core principles of our constitutional framework. But also in the 14th Amendment is the birthright citizenship clause, which, as you alluded to, Demetria, makes clear that anyone born in the United States is a citizen of the United States, thereby restoring what had long been understood to be the case. So this is the importance of that right. This is the sort of history that we're talking about. And for centuries, it's been understood that the 14th Amendment does indeed guarantee birthright citizenship to everyone who is born here, until the Trump administration. And the very beginning of his second term in office, President Trump issued an executive order that, as Demetria explained, sought to deny birthright citizenship to a significant number of people in this country. And there were a number of lawsuits challenging that order. And courts uniformly recognized that this order is unconstitutional. It is inconsistent with the 14th Amendment. And what's so extraordinary about this case is that the administration did not go to the US Supreme Court saying, oh no, actually, we're right on the law. Instead, it went to the US Supreme Court asking the Supreme Court to say that, well, even recognizing perhaps that they are wrong on the law, that courts somehow do not have the power to tell the government, you have to follow the law. So the specific issue in the case is, what is the authority of the district courts to say to the federal government, you have to follow the law? And you have to follow the law not only with respect to a specific plaintiff who maybe brought the lawsuit, but you have to follow the law in general. You can't deny birthright citizenship in general. And so that's what the case was about. That was the issue before the court. And quite troublingly, a 6-3 majority of the Supreme Court held that in general, there cannot be something known as a universal injunction. And that's sort of a legalistic sounding term. But as Justice Jackson pointed out in dissent, what really the case is about is, can the courts tell the government to follow the law? And the 6-3 majority said, well, not always. That in order for a court to tell the government to follow the law, there are additional sort of procedural obstacles that have to be addressed. There are specific sort of ways that a case maybe can be litigated, and I think we're going to talk a little bit more about that. But that in general, district courts cannot just sort of say to the government, you have to follow the law. And that is what is so troubling about the Trump versus Casa decision.
That's a lot. That's a lot. But thank you for taking us back to the beginning, right? Back to the beginnings as we know it. This is going to have a huge impact, really far-reaching impact on really vulnerable families. What does this case mean for those vulnerable families across the country?
If the Trump administration is able to implement any part of its order, the consequences are going to be dramatic. They're going to mean that parents are not going to know if their children are going to have citizenship. They are going to potentially affect people as they grow up. People who are born here not having the full range of citizenship rights that have so long been understood to be part of what our country is about. And at its core, of course, this is an attack on our multiracial democracy and an effort to fence out some people from being full participants in our multiracial democracy. The order will still not be able to go into effect for 30 days. And so in that period of time, the lower courts will be able to consider whether even under this new restrictive case, there is a way to ensure that the order does not go into effect. And the other thing I think is important to note here is that on the very day that this decision came out, the Legal Defense Fund, along with our partners at the ACLU, at the Asian Law Caucus, and at Democracy Defenders Fund, filed a new action called a class action. And the idea behind the class action is that there is an opportunity for everyone who is impacted by the order to be considered a class, and then to have that kind of broad relief that the court said was likely unavailable in the cases before it. So there continue to be challenges, and this is exactly what I think Janae was talking about at the beginning, where we see how the court is making it so much more difficult to vindicate certain basic rights. And we at LDF are going to continue to work to do so, even as we see these new challenges.
The work continues. Thanks. Thanks. So now, this isn't the only kind of immigration-related case. There's another immigration case called the Department of Homeland Security versus DVD. You mind sharing a little bit about that one?
Yeah, this was a very troubling case. And essentially, the issue in the case is for immigrants who are in the United States and who receive something called an order of removal, which means that the government is authorized to have them removed from the United States. But imagine you're in a situation where you flee to the United States, you're facing persecution, and you are in danger if you go back to the place that you came from, or potentially a third country. And under the law, even once there's an order of removal, Congress has made very clear that there has to be an opportunity for someone who is facing this removal order to be able to show that the country that the United States is suggesting the person should be removed to, or seeking to mandate that they be removed to, that that country would not be safe, that they would be at risk of torture, those sorts of things. And what happened in this case was the Trump administration, in defiance of a court order, forcibly removed a number of immigrants to sought to remove them to a number of countries, including in one case to South Sudan. They had no ties to South Sudan. They had no opportunity to show that they had credible fears of being tortured if they were sent to South Sudan. And so a district court said, you cannot do that. And the United States Supreme Court, with no reasoning, the same 6-3 majority, stayed that order, meaning blocked the order, and allowed the administration to proceed. And so this is a very troubling ruling where the court is essentially facilitating lawless conduct by the administration and preventing the basic due process rights of immigrants in this country from being vindicated.
This is a really scary times, really scary times. Thank you, Sam. Thank you for sharing that. All right, now I'm going to kind of move a little bit and change gears a bit and talk about another major issue that came up this particular term, folks. This one's related to political participation and redistricting, okay? And for that one, I want to bring on Todd. So this March, as you know, LDF's very own Stuart Knife, manager of the redistricting project, argued before the Supreme Court in Louisiana versus Calais. Now, this case is actually considered to be rather complicated. So Todd, our expert here, can you just break it down for us? What exactly is Calais all about, and why did LDF bring the case in the first place?
Sure. Let me just set some context. At its core, Louisiana versus Calais is about equal representation for Black Louisianans. In 2022, the Louisiana state legislature passed a congressional map that completely failed to afford Black voters an equal opportunity to elect their candidate of choice. And let me provide some context to that. Black voters in Louisiana have been persistently excluded from fair representation throughout history. And in the political process that they participate in, they've not had a chance to elect their candidate of choice in any of the remaining non-majority Black districts, given the voting patterns in those districts. So LDF sued, arguing that the map that they created violated the Voting Rights Act. In response, the Louisiana legislature passed a new map with 2 majority Black districts in 2024. Instead of passing the map that LDF proposed in the litigation, they passed a different map that prioritized political interests. A group of self-described non-African American plaintiffs filed a lawsuit claiming that the legislature's use of race in drawing those lines was not justified under the Voting Rights Act and therefore violated the Constitution's Equal Protection Clause. LDF's argument that Louisiana's remedial congressional map that was created with that historic second majority Black district meets the requirements of both the Voting Rights Act and the Constitution. And it fairly reflects the unique representation needs of the candidates preferred by Black voters in Louisiana. However, the lower court disagreed, and that decision was the one being reviewed by the Supreme Court. Now, it was unusual what the Supreme Court decided to do in this case. In a unique turn of events, instead of issuing an actual decision in Calais, the court decided instead to ask that the case be re-argued.
So we're all going to be holding our breaths to see what the Supreme Court does next term. But Todd, what exactly is at stake for the people of Louisiana, and what could it mean for people across the whole country, this case?
Sure. Well, for Louisianans and for Black Louisianans in particular, who have fought for fair electoral opportunities, have fought for the right to elect their candidates of choice, the stakes are quite high. These community members have fought very hard for this opportunity. LDF litigated a case that afforded that opportunity with these two majority Black districts. And at its core, Calais is about, as I said before, equal representation for Black voters in Louisiana and a determination of what the proper role of race is in redistricting. And courts have ruled that Louisiana must comply with the Voting Rights Act. And the way we interpreted that and the way courts in the past have interpreted that is that you must afford the voters an equal opportunity to elect candidates of choice. And what that means in this situation is the creation of two majority Black districts. They deserve equal opportunity to exercise their political power, and this is the way we've determined it's going to be afforded. And the law and facts call for fair maps, and the law is well established in that. And we helped establish it, again, in a case called Allen versus Milligan. The U.S. Supreme Court upheld decades of precedent in that case under Section 2 of the Voting Rights Act and recognized that attacks on voting rights of Black voters continue today. And that case led to fair districts being drawn in Alabama and signaled the same should apply in Louisiana. So Black voters finally had an opportunity to elect their candidates of choice in these two districts in Louisiana in 2024. And that opportunity should not be stripped away in this particular case. And the fight for fair maps continues in Calais.
Well, thank you for that. You know, redistricting is critical for voters, especially Black voters, to be able to actually elect the candidate of their choice. Their congressional representation ultimately decides whether there's Medicaid and SNAP benefits, right? Whether there are Pell Grants or Pell Grants are taken away, which we all painstakingly witnessed. All right, folks, we are halfway through to the next census, okay? And the next redistricting cycle is going to come up in 2030. That's not that long from now, folks. And LDF is working with our partners to lay the groundwork for successful advocacy and litigation to ensure that everyone has their voice heard and that their votes are counted. And so this preparation period, right, is essential to ensuring residents in Louisiana, Alabama, all across the United States are actually educated about the redistricting process, and that they actually have the capacity to provide robust and meaningful input to legislators to ensure that district maps represent their communities and their interests. So again, Todd, thank you very much and helping contextualize all this for this very moment that we're in. So much is happening both in Congress and at the state level. And thank you for your leadership and all this work that lies ahead. All right, now we're going to move on to another category here. We're going to move to an issue that's before the court with Sam again. So let's start with the Scrimeti case, right? So last September, LDF filed an amicus brief in this case where we argued Tennessee's healthcare ban that was grounded in discrimination and that it would actually be detrimental to the health and well-being of transgender youth. So now, what exactly does this decision mean, and what is at stake for the transgender community and those who love them and their allies? What does it mean going forward? Sam, help us out here.
Yeah, so this is a hard one to talk about because it was such a devastating ruling, as you said, Demetria, and I think such an indefensible ruling. The background here is that a number of states, almost half the states, have enacted healthcare bans for transgender youth. And so under those bans, if you are a transgender child, and you and your family and your doctors all decide that some kind of gender affirming care is appropriate, that that care is illegal, that you cannot get that care in the state that you live in. And it is quite troubling that any state would seek to prevent doctors and parents making those choices. And I should say that this is care that, as the district courts in every case that there's been a record has recognized, is well established, as accepted by the medical community, as in many cases life-saving. This is literally life-saving care for teenagers who would otherwise be forced to go through puberty in ways that are not consistent with their gender identity. And nonetheless, states, as Justice Sotomayor explained in her dissent, are essentially subjecting transgender children and their parents to political whims, to the moment of potential disfavor or targeting. And so there were constitutional challenges brought in a number of these jurisdictions, including in Tennessee. And the district court recognized that Tennessee's ban violated the Equal Protection Clause, the basic principle that the government has to treat people equally and that laws cannot be premised on animus or discrimination. And the Court of Appeals disagreed. And then the United States Supreme Court, in a 6-3 decision, agreed with the position of the Court of Appeals and held that there was no equal protection violation. So it really is a devastating ruling. It is inconsistent with well-settled precedent in a number of different ways. And as you said, Demetria, the point that LDF made in our amicus brief was that it's clear that this law and similar laws are infected, at least in significant part, by animus, by an effort to target transgender people. And to see the Supreme Court abdicate its constitutional responsibility to enforce the constitutional rights of the most vulnerable, that's the moment when it is most important for the Supreme Court to enforce constitutional rights, when people are being targeted, when they are less popular, when they are facing discrimination. And for the Supreme Court not to do that in Scrimeti was quite devastating.
And so while we're talking about health, let me turn to Medina versus Planned Parenthood South Atlantic, right? That challenged South Carolina's prohibition on healthcare clinics that provide abortions from those who are participating in Medicaid, right? But as we all know, Planned Parenthood actually provides far more services than abortion care. And so this will likely have a major implication on LGBTQ plus communities across the nation as it relates to access to healthcare, right? So can you talk about this and what this case might mean for these communities, Sam?
The impact of a decision like Medina it's disproportionately going to harm LGBTQ communities. It's just going to disproportionately harm Black communities and other marginalized people in this country. And the background here is that under the Medicaid statute, there is a rule that if a medical provider is qualified to provide a service, the patient should be the one deciding where they want to be able to obtain the service. And so, as you said, Demetria, Planned Parenthood provides all different kinds of healthcare. And patients who want to go to Planned Parenthood to obtain healthcare, for whom Planned Parenthood is the most accessible, or where they feel the most comfortable, or where they think they're going to get the best quality care, under the Medicaid statute, they should have the right to be able to do that. And so the Supreme Court did not disagree with that idea, did not say, oh, actually the Medicaid statute means something different. What the Supreme Court said instead, and back to the theme of who is able to actually enforce the law, the Supreme Court said, well, you actually can't, you Planned Parenthood, you patient, you somehow don't have a right to vindicate your rights under the Medicaid statute. That the only way to enforce that provision in the Medicaid statute would be for the United States government to say, oh, South Carolina. And you can imagine whether that's likely in this administration and this climate, and it's not. But even beyond that, it's not for the United States to be the arbiter of whether individuals can have their federal rights vindicated. And so, again, you have this decision in Medina that is quite troubling directly in terms of the impact it's going to have, but it's also troubling about where we are as a nation that claims to be committed to being a nation of laws where the government has to respect the law.
That's right. That's right. That's exactly right. That's exactly right. Medicaid's been in the news a lot these last few days for other reasons, but this is again troubling. This is again troubling. So what I want to do now is we're going to bring Todd back in, and we're going to talk about a really controversial case around workplace discrimination, right? And this case is called Ames versus Ohio Department of Youth Services. And so this one too is complicated, right? So Todd, for us, please clarify exactly what the court decided in this case and what it means for all of those of us who are on the screen today with us watching.
Sure. And let me just put this in context. For Black workers and for other marginalized community members, discrimination in the workplace is not something of the past. It is a persistent reality for them at the workplace and in their employment situation. Title VII of the Civil Rights Act of 1964 continues to be a critical tool in protecting people in the workplace, especially now when, as we've been discussing, so many initiatives meant to ensure that everyone is on equal footing in the workplace and everywhere else in our society are under direct attack. The plaintiffs in Ames really tried to turn that reality on its head by arguing that the cards are actually stacked against non-minority plaintiffs in employment discrimination lawsuits, which is a very prominent narrative being advanced by those who are against civil rights right now. Those claims are not grounded in fact. And studies have shown that courts actually aren't interpreting Title VII in a way to disadvantage majority group members. And because there have been so many misleading headlines about this case, and so many folks are looking at Ames, this narrative that I just articulated in a way that we find troubling, I really want to set the record straight. First of all, nothing in Title VII's key principles regarding employment discrimination and the protections that Title VII provide, none of those things were disturbed in this case. The court's decision in Ames actually clarified what we at LDF have been outlined in our brief and we've been saying for quite some time. It is well established that everyone is entitled to Title VII's protections, regardless of whether that person might be considered a minority or not. The law must be applied equally to everyone. And that is a firm, established principle. Second, nothing in this decision means that white employees are at an advantage when attempting to bring an employment discrimination case to court. What the court did do was correct a misunderstanding several lower courts have had regarding how to apply the relevant test in this particular situation. And finally, again, context matters. America has a shameful history of workplace discrimination against LGBTQ members, community members, Black people, and countless others. And for many marginalized groups in this country, workplace discrimination is not, as I said before, a relic of the past. The court did not deny this. Instead, Justice Jackson, writing for a unanimous court, reiterated what is required for a person to prove their case for discrimination and what you have to put into the record in order to make your case fulsome in reality. Courts are still able to consider the discriminatory obstacles that block certain groups from equal employment opportunities, and nothing in this particular case disturbed that. And the last thing I'll say is that this is not a loss for what folks have been describing as diversity, equity, inclusion, and accessibility. Ames did not touch any of those policies, which we believe are critical to ensure equal rights and ensure that civil rights are properly implemented in so many facets of our society. The court's opinion did not touch that at all. And it did not mention diversity, equity, and inclusion and accessibility at all. So I want to also dispel that misconception.
Well, Todd, thank you for setting the record straight. Appreciate that. All right, so now let's talk about this case that I think has been in the news quite a bit. Maybe folks have heard about it, Mahmoud versus Taylor. All right, so Sam, bringing you back in, can you talk us through what this case is all about?
Yeah, so essentially what was happening in this case is that Montgomery County Schools decided to ensure that their curriculum would include the existence of LGBTQ people and have books, including books for children, showing the celebration of life events for LGBTQ people. There was no effort to indoctrinate any student about anything. There was no suggestion that students whose religious beliefs might have different perspectives, that those religious beliefs are in any way immoral, nothing like that. Simply children's books that acknowledge the existence of LGBTQ people and that LGBTQ people, like all people, are worthy of respect and of love. And nonetheless, the Supreme Court, another 6-3 decision, holds that somehow the mere existence of these books as part of a curriculum would violate the religious freedom rights of parents who may have religious beliefs that are, from the court's view, somehow inconsistent with what the court deemed the messages of these books. And that was particularly strange, as the dissent pointed out, because the parents who had been seeking to exercise these religious freedom rights had themselves said, we do respect LGBTQ people. We want our children to respect LGBTQ people. We may just have a different view about something like gay marriage. Nonetheless, the court said that the mere exposure to these concepts, again, the concepts being the existence of LGBTQ people and the idea that LGBTQ people, like all of us, are worthy of respect and love, that exposure would somehow violate religious rights of parents, and therefore there have to be opt-out opportunities for parents in order to say we don't want our children to be part of this part of the curriculum.
I'm getting a little confused here. 1 minute we're hearing that they're taking parents' rights away as it relates to their kids. Now we're saying the parents get to have all the rights they want with their kids in the school setting. Okay, thank you for that very much. I appreciate that. Folks, I know it's a lot, but having that context and understanding is just so very critical in helping us sharpen our focus and helping us be strategic on how we'll combat further retrenchment. All right? So, last issue of the day. I'd like to bring in Jinhee Lee to speak to the excessive force cases that were before the court. Barnes v. Felix. All right? Jen, explain for us, please, will you, what this case is about and what it means for the public at large. Please, Jen.
Barnes v. Felix is an important case that the Supreme Court issued this past May. It's a case where LDF proudly joined with the National Urban League and the law firm Melvini and Myers to support a continuation of the legal doctrine that has governed whether or not a police officer has been justified in exercising its use of force. Oftentimes, tragically, that may lead to a fatality and the death of someone. This is an issue that is so critical for LDF. In fact, one of the seminal cases in this area, Tennessee v. Garner, which was a Supreme Court case issued in 1985, was an LDF case, and in fact, in the Strategic Initiatives Department, we have a Justice and Public Safety project that has been dealing with the problem of excessive use of force by police officers against Black people for 10 years now. We're in our 10th year in that project, and of course, the issue of police violence against Black people was the central focus of the racial justice protests in the summer of 2020. And so just giving you that backdrop so that you understand how important this issue is and why it was important for the Supreme Court to take on this issue. Now, the specific legal issue that was being addressed in this case was what is the totality of circumstances that a court may consider when determining whether an officer was objectively reasonable when exercising use of force. And oftentimes that use of force is a weapon, a gun, and the shooting of another person. And in the Fifth Circuit, which is where this case came from, the Fifth Circuit Court of Appeals had what is called a moment of threat rule. And what that meant is when determining whether or not an officer was objectively reasonable, they only looked at that very cabined, few seconds when the officer actually shot his or her weapon, and would not consider all the other circumstances that might have happened, moments beforehand, perhaps, minutes, hours beforehand, other kinds of information that might be relevant. And in Barnes v. Felix, the Supreme Court unanimously ruled in a decision authored by Justice Kagan that the moment of threat rule was inconsistent with our Supreme Court precedent, that the totality of circumstances meant the totality of circumstances and should not be limited in just those, split seconds or just the seconds during the time when a police officer may have felt that their, safety was at risk and caused them to fire their weapon. And this is very much illustrated by the facts of this case, because it was a situation where a police officer voluntarily jumped on to a moving vehicle and then made the case or argued that, the fact that he was on a moving vehicle is what caused his physical safety to be at risk. And that is why he shot into the car, ultimately killing the driver. But in that determination as to whether or not that was objectively reasonable, the court did not consider the fact that the police officer put himself in that position, that he voluntarily jumped onto a moving vehicle. And so this is an important case. It allows surviving families and loved ones who have family members or friends who are victims of police violence to be able to challenge those acts of violence and to be able to bring to the court all relevant evidence to demonstrate whether or not the police officer was objectively reasonable in using force. And this is especially important in the Black community because of the inherent racial bias that we see in law enforcement practices. This has been documented and researched at nauseum. This is not an opinion, this is a fact that Black people are more likely to be considered to be violent or to be criminal without any kind of evidence supporting that. This is just based on the racial stereotypes that exist in our society. And when police officers encounter Black people, the situation is more likely to escalate because of those inherent biases that police officers, but all of us hold because of the implicit bias that we have in this country. And so this is really important for courts to be able to consider all the evidence and not, kind of fall prey to these biases that we often see in these police encounters. And it's also an important example of how important the Supreme Court, but also courts around the country, federal courts and state courts are in upholding the rule of law. I think when it comes to criminal justice issues, the current administration has been very vocal in trying to advance a more aggressive and militaristic form of public safety and law enforcement practices. These are the same practices that we know to be ineffective and an utter failure in leading to mass incarceration and the criminalization of poverty. And yet We have an administration that is trying to turn back the clock and go back to practices that we know have been an utter failure. And it is important in these situations for courts to be able to push back against those tendencies and uphold the rule of law. And this is going to be more and more important as we see, potentially other acts of aggression by this administration, and the expanded use of law enforcement against Americans and others here in the United States.
So right now, folks, I just want to thank my colleagues for sharing their expertise and helping us actually make sense of this year's Supreme Court term. Listen, we've all got a lot of work to do, but as Janae says, LDF was built for moments like this. So before we close, I want to bring everyone into the conversation. So that includes you, right? I want to bring everyone into the conversation to answer the key question of the day, which is, what can folks watching right now do to support this work and protect our civil rights? What can we do?
So I would just say that we have seen that on one hand, we're not going to give up on the Supreme Court, and the Supreme Court in some of the more difficult cases has put barriers that LDF and other civil rights organizations will continue to find a way to overcome the barriers. But what we have seen is that the Supreme Court is not going to save us from the troubling attacks on the rule of law, the troubling attacks on our multiracial democracy at both the federal and state level. And it is up to all of us to make sure that we are doing our part to advance the rule of law, to fight for our multiracial democracy. And those may sound somewhat abstract, but there are concrete ways that we all can make sure that they're not abstract. Those ways include doing our parts to make sure that we do have fair employment practices where we work, to remember that diversity is a value, it is essential in our multiracial democracy, and to be at school making sure that we are teaching students in ways that are reflective of our historical reality, both the good and the bad, that all students, students of color, LGBTQ students, all students are treated with respect and dignity. And so there are things that each of us can be doing in our own lives, in our workplaces, with our children, in our schools, to make sure that we are moving the ball forward with respect to the future, the promise of what this country should be all about, and what the Constitution promises all of us who are part of this country, that we are all in this together and that we all need to move forward together.
If I could just add a little bit, sort of building on what Sam said, I do think it's important for folks to think collectively. At LDF, we say we need to defend the rights that we've fought hard to win. We have to disrupt the current work afoot by this administration and by others to undermine civil rights and to roll the clock back. But then we also can't forget to dream. And so I think what folks can do next, as we were saying in this segment, this part of our session, is to think collectively, as Sam alluded to, but also dream collectively about what kind of America we want to see. And I dare say the kind of America we want to see is one where the government is accountable, among other things, and that the rule of law is adhered to. And I think those are important dreams and important aspects of our collective vision for the future of America. And I really encourage everyone to think hard about how they can work to advance those visions and those dreams.
And we all have our various types of circles of influence, right? And so we've got some business and C-suite leaders. What can they do? They can back diversity, equity, inclusion, and accessibility efforts, right? Those types of programs and civil rights litigation, and maybe leverage their networks, call on peers, employees, partners to take action and advocate, right? They can actually champion transparent, equitable practices, right? Using influence to actually protect anti-discrimination policies internally and across industries, right? That's not the sphere of influence I'm in, but others may be, right? And they can also amplify impact, right? Use platforms to raise awareness and share grantee resources and connect movements with policymakers, media, and the public. And for all of us, kind of what Sam alluded to, educate ourselves, right? Study civil rights history, attend webinars, share what you've learned today and other times with colleagues and friends and what have you, and just stay committed for the long haul, right? Some of us, I know it's hard right now, we want to give up, but let me tell you something, social change takes sustained effort and strategic vision. And so before I close, I want to make sure that you're aware that I'm sending you out with a few resources to have for the coming days, okay? So in addition to this recording of this webinar, we're going to share LDF's annual U.S. Supreme Court Roundup, right? Which is written, right? It's a written review of the key cases, right? From this particular term, from the 24-25 term. And in the fall, we're going to release an overview of civil rights cases for the upcoming term. So you can look for that from us. And in addition, what we're going to do is we're going to share information on how you can join the Black Voters on the Rise Election Protection Network and consider serving as a poll monitor. That's LDF's own, we call it Be Voter here, Black Voters on the Rise. So thank each and every one of you for attending today and for listening and for standing with LDF as we fight for racial justice and equality for all, for everyone. Thanks for being here.
This concludes our webinar. For the latest news, please follow us on social media.